38, PR38, an extra PR38. Your Honor, we have a next photographs of security vehicles.
With your kind permission, I wish to raise an objection. And my objection, Your Honor, is founded on section 106B of the Evidence Act.
That is your name.
Release of your counsel first accused. Section 106.
Based on
Section 106B
on electronic evidence.
on electronic evidence.
You'll get your time.
I'm not raising an objection because it's kind of part of it.
You get your time, get it.
Also, we have a next
Please, I want to confuse the director.
Yes, sir. We have next a series of photographs marked as RR1 to RR37.
1, 2, R.
37. Your Honor, those photographs depict vehicles belonging to ACC, National Police Service. Your Honor, those that were vandalized at the residence of the accused person yesterday, when the officers were executing the lawful unit.
Executing.
Their lawful mandate. That is, doing a search pursuant to miscellaneous application E716 of 2025.
Come again. Miscellaneous application number.
E716
E716.
of 2025. That is stated in paragraph number 4. You know, photographs RR3 to RR10. RR3 to RR10. They depict motor vehicle KCH 046T.
Come again. 0.
460 after it had been balanced. There are photographs R11 and 12 depict KCB 628X after the balanced. Photograph R11 KBU 7.41 RR26, the motor vehicle KCF, U KCF 541U. Then at paragraph 7 and paragraph 8, the officer depots,
Sorry?
paragraph 7 and paragraph 8, Mr. Ronald depots that after vandalizing these vehicles, important documents were taken. Now we take judicial notice of the position of the first case. The witnesses in this case, Your Honor, upon disclosure, are his subordinates, people employed under his government. Now, what is the test of interfering with witnesses? It is not beyond reasonable doubt. The test is just a reasonable prospect that is will take with the witnesses.
The test is?
A reasonable prospect that the accused person will tamper with the witnesses and the evidence.
You know, perhaps, and I'm aware of the directions you have given about the temporal. Perhaps we need your guidance whether counsel can go outside the content of his affidavit and claim to bring averments that are not contained in the affidavit, because that will prejudice us in terms of our response. Because there is no averment in the affidavit that effect that the proposed witnesses are subordinates of the government.
I'll give a guidance again. Whatever you pick along the way from both submissions, kindly bundle them together. Once you rise, I expect that you address all the issues in one sweep.
I wonder.
But let me record you first. Mr. Kula, give me some time. I need to record his objection. Everyone have I need to
I will repeat you, Honor.
How long more? I thought we were going to take 3 minutes. Now we are going to, will we sit here the whole day? Just off the cuff. How long more?
I'll take it, 10 minutes. Let's summarize this.
10 minutes. Continue, Mr. Cook.
Yes, sir. I will repeat
So
that.
your 10 minutes.
we are submitting that once disclosure is done, the witnesses will be calling the officers from the first accused. Those are disadvantages. I'll get the second claim. It's a very good offense. I got the second compelling reason. When appraisal of the title, the amounts will appear caution.
The amounts will appear.
Minimum, 1 million. I should believe Your Honor will win this case, and will draw your attention to section 62(1). 62(1). In the event we succeed, that provision is very punitive.
In the event,
We succeed.
we is
The
the
DPP prosecutes this case. We get a conviction.
is successful.
Yes. We will be moving to section 62, subsection 1. And on that, the severity of corruption cases. Will it be a recipe for someone to interfere? We submit in the positive. Your Honor. Lastly, public safety. I've alluded, Your Honor, to what transpired yesterday. And I've alluded that investigations with regard to other cases are ongoing. Our submission is that if we release the accused person today, what transpired yesterday will happen. And we are apprehensive that in the interest of justice, in order to protect the integrity of the criminal justice processes, that our application is out, and at least for the court to have an independent opinion, a plea bail report be available. A plea bail report be available before this court and decide on this issue. Thank you.
Mr.
Sorry, Your Honor. Just to underline that our prayer is that the first accused be denied bail. That probably is the last sentence. Thank you.
Mr. Jerome, how many of you would like to plead this with? Because I listed, how many? I listed 11.
Yes, and one, not all of us, not all of us.
So how many? Just to manage our expectations.
About five of us will be free. We do from drama. You know, drama, we just want to do for issues. Because the issues are straightforward, you know. Okay, let me start by introducing Senior Counsel John Greenwan. He's Let me be the first one to just give some. Let me on the outset state that the prosecution is causing unnecessary drama in an otherwise straightforward matter. And our focus at this point will be the rights of the accused person who remains innocent unless and until he is proven guilty. So no amount of reasoning. Yes.
Yes.
So no possible grounds can be advanced that can be directed at taking away the accused person's rights. That should be the starting point. And sometimes, Your Honor, as a counsel was now practiced for 33 years, I get concerned when
How long is that?
33 years.
That is not for intimidation.
When we
But I'm sure Dr. Hamina is smiling at you.
Actually, it's a sign.
Very sad.
Your Honor, when prosecution purports to teach this court the law, citing authority, citing sections, and tell you how to deny an accused. Before I stand here and pass along, I'm certain they do not believe in what they're saying.
Sorry, Your Honor. I know the court warned us of decorum, but we plead, I am just 12 years in practice. We plead that senior Macharia doesn't get personal. We are just here for our cases. Anything that we do is not personal. So we plead with him to have mercy on us and just stick to his case without attacking us.
Thank you. Mr. Jennifer, to record the objection. There is a special reason, Mr. Njero, I did what I did to your side, so that we remain focused. So remain in that trajectory.
Absolutely. My plea is that we have mercy on the accused person. Let's not talk about mercy on the prosecution or media. We are outside. It is him who's left in custody. Now, Your Honor, I'll say this with tremendous respect. What we have here is warfare, which I urge you, Your Honor, to take judicial notice of, because we live in this country, we are interacting with social media, we know what is happening in our country today. And none of us can afford to shut our eyes from that.
independent agencies are being captured and being used to weaponize matters of justice. That's what lawfare is all about. Where you use legal processes to attain an ulterior objective, which is to harass political opponents. It is sad, extremely sad. Your Honor, I'll make a confession to you. I was last in a criminal court defending somebody 20 years ago. But this matter made me extremely agitated, and I said, I will come back to the criminal court to defend someone. Not because of his status, because we can't allow a country to degenerate to a situation where the criminal justice system now be used to harass opponents. That's wrong. And we shouldn't allow it. Your Honor, intimidate. I am one of the few lawyers who have had the advantage of having been part of independent agencies and also been private practice. One of the few. And I know how things operate in those agencies. I am on the first year of independent police oversight authority, and we had a lot of run-ins in the executive. Constant interference attempts to direct us on how to do our work, including by the current president when he was deputy president. And this is factual. It's in public domain, it is known.
Mr. Njero,
I'll give the context. I'll give the context. Your Honor.
the focus.
Yes, I'll give the
The
context.
focus there, Mr. Njero, a minute,
I'll give the context.
Mr. Njero. The focus here is the accused, the law, the constitution. You understand our parameters, if you like.
I'll
There are some parameters I am unable to swim in. I may not be very able to swim in, but I can swim in the constitution, I can swim in the law, I can swim. That's why I can swim in submissions around those lines.
The reason why I'm telling you that, Your Honor, so that I can go straight to the context,
Yes.
is that independent agencies will come here and pretend more often than not that they're doing their work independently. I'm telling you, as somebody who has been in those agencies, that unless as an individual you have the wherewithal to resist and do your work correctly, very few money to do that. That's the context. I'm not here to talk about where I was.
Sorry, Your Honor.
It's just to indicate.
Sorry, Your Honor, we are forced to object once more on the question. The factual matrix that the very learned senior is giving us are things that, with respect, he cannot tell us from the past. We would believe him, and I know he's a very truthful man, but for us to believe what he's telling you to believe, let him give us an affidavit of those facts so that we're able to respond to those facts. Without that, we humbly plead again. We humbly plead that he gets back to the case and not tell us the other things that are factual and there's no affidavit. We plead with him. We understand that he's previously the commissioner, we understand. But let him get back to our case. Thank you.
To respond to that, look at the
A minute, Mr. Njero. I complete the recording.
Problem number one, they serve us in a affidavit this morning. What time did they expect us to respond to that affidavit? You know what is the trick? That it is designed in a manner that will expect us to make an application for adjournment so that we can file an affidavit. And in the meantime, the accused person continues languishing in custody. You know those tricks? Then the affidavit itself is marred with general averment. This is factual. They are talking about respondents agents, they are not naming which agents.
So just to be clear, you responding to the objection or you continued with your submission?
I'm responding to
That I'm
something
clear.
here. He cannot say that I'm making general averment, yet in his own affidavit, he has made very general averment that in support of denial of bail. Then he expects that I shouldn't be able to respond to that. At least from the back. In the very least, that should be expected. He can't have a steak and eat it. In fact, we should be given more latitude because the subject of these proceedings is the accused person. The rest of us are sleeping here, and then we walk away. But this is the subject. That is the person we should focus on.
Give me time to give direction. Somebody wish to guide again, that we focus on the law governing golden gate. That is the issue of the table. Continue, Mr. Njeri.
Much obliged. Now, Your Honor, the accused person is somebody who has served this country for a long time, not just as a governor. Knowledge of who he is in the public domain, including the very sensitive security agencies. And he also understands the law by his own right. He understands his obligations to the public security. Besides being a governor, elected governor of the country. What was so difficult was just someone to court, telling me to appear in court and such a thing. Why all the drama? Arresting the man and putting him in custody for this kind of charge. Why? It can only be for the sole purpose of punishing him. Can't be anything else. And it is that desire to continue punishing him that is driving the application for him to be denied bail. You cannot allow yourself in realizing that objective? You can't. I have consistently seen the last line of defense of this country. The only one remaining, Your Honor, is the judiciary. And if judges and judicial officers allow rights of accused persons to be taken away, we have no country. None whatsoever. And let's not think that when you allow that trajectory, that everyone will be safe, including the prosecution itself. No one, I can tell you, Your Honor. We need to learn from history. So regardless of what happens here with these protracted submissions and responses and comments and media, Your Honor, I beg, do not fall under the trap of saying that they're going to write a ruling another day to be meted in this custody. Don't allow this man to remain in custody. He's already been punished enough by being put in custody, even for that one night, when he could have been summoned to appear in court, and he never appeared. One of my colleagues here will speak about the facts, then the chaser, but I can tell you, Your Honor, this alleged misfunction that is being talked about, the accused was in Nairobi. Whatever is alleged to have happened was in Kitale. How do you start connecting him to something that is happening hundreds of miles away when he was in the office of EACC? How? So I'll allow my colleagues to say something, but I'll end by saying this. The reality of our times is that between now and 2027, these are the kind of things you're going to see continuously. Warfare, use of the criminal justice system to intimidate and harass opponents. Your Honor, I once again plead with you, do not fall into that trap. I'm confident you will not do it.
Thank you. Thank you, Your Honor. Briefly, just give the last aspect.
You can continue, Mr. Jiro.
Your Honor, just to associate myself with the submissions made by Malani Senior, and to draw your attention to the content of the charge sheet, from where you will be able to drive the mischief. And the accused person is currently
Slower. Pause after every sentence. The accused person.
It's not surprising that the accused person is charged before you with another person, Wafula Masungo, who is not before you. This is not by coincidence. It is not that Wafula's whereabouts is not known. It's because, Your Honor, the state was in a hurry to perpetrate this mischief. In normal circumstances, Your Honor, such proceedings would not have commenced. When we sought for explanation, Your Honor, Malani Senior indicated that he was seeking summons. It's the same mischief, Your Honor.
Slower.
When you sought for clarification from the prosecution,
Slower.
the opposition, Your Honor, was that you seek summons. And the nature of the summons was not indicated to you. That is to say, Your Honor, therefore the application for you to deny appeal must be read in light of that mischief. That other than pursuing public interests as dictated by Section 4 and 5 of the ODPP Act, the ODPP is equally pursuing other ulterior motives that are politically actuated.
And our apologies. Passing to the directions, Your Honor, to direct the focus on the charge sheet. It comes to pass anyway.
Minute.
Pass on the directions.
Minute and recording is start.
The direction.
Minute, I'll give you directions.
na lile ambalo limetumika lipoenda fanywa
bado service.
And the issues related to bail. The colleague is submitting on a fact. Unless he has evidence as to what he wants to speak about, we will ask him to take the stand on the other side and we will read the evidence. So let me speak on bail. The guys of this person. We just not inflict any motive to anybody unless they are willing to take the law.
The response is Kanjiru.
Your Honor, my response is contained in the affidavit filed by the ODPP. But it's not surprising, Your Honor, that the affidavit contains mere speculations. It has no tangible evidence that proves to the contrary of what I earlier submitted. If I also proceed in response to the substantive application,
Minute. Must give direction and objection. I remind that once more, I think belong to the law on bond and bail. To avoid instances which may persuade me to request the fact of being evidence from your end,
I am well
which
ready.
will render you in a very awkward position.
I am well ready.
All right.
Your Honor, the affidavit contains mere speculations. There is no affirmation in the affidavit.
Minute, after every sentence,
Under the is no averment in the affidavit that is linked to the charge sheet before you. The averments in the affidavits have no nexus with the charges before you. These are matters that are happening in other spaces, which none of us, neither the prosecution, nor the defense, nor the court, are privy to. That is to say, Your Honor, that to deny the accused person bail on account of presupposed investigations would be tantamount or will amount to violating his constitutional rights. And most importantly, the right to presumption of innocence and the right to liberty. The argument here the argument are subordinates to the governor, the accused person. Again, is not contained anywhere in the affidavit. And the same does not amount to a compelling reason. And so to say, the argument that vehicles were destroyed by his agents when there is clear lack of evidence linking the so-called agency with the accused person, again is speculative. Has no probative value of whatsoever nature. The same is not empirical, and there is no nexus between that averment with the affidavit and the accused person. And as such, that cannot be considered to be a compelling reason. More annoying, Your Honor, more annoying is that the office of the ODPP, which is fully funded with the taxpayers' money, had no courtesy of proving the ownership of these vehicles. Your Honor, the producer of the so-called annexures, for instance, will not tell you who is the registered owner of KBU 734Y. Again, from the same annexure, you will not tell who is the registered owner of KCH 046T. It will not tell you who is the registered owner of KAE 7-8F. And you're being invited to deny bail on that ground. Registration of motor vehicles is a legal process. It is guided by the Registration of Motor Vehicles Act. And if you are courteous enough, respectful to the process and the proceedings, and holding the values of the Constitution of accountability and transparency, they would have consulted the NTSA. Permit me just to, as a pen off, and invite my learned friends to draw your attention to the charge sheet once again, that there is no charge that the government is facing that is linked to his office. There is no way in the charge sheet that says that the governor acts his office. There is no way in the charge sheet where there is a charge of conflict of interests. That is therefore to say, in the absence of such kind of a charge, in the absence of evidence, the argument and the affirmance by the prosecution is not to be believed. I was perplexed, Your Honor, in summary, when I heard my learned friend Mr. JV invite you to look at Article 50 in isolation of Article 25, in light again of Section 8 of the Magistrates Court Act. He invited you to hold that the only jurisdiction you have in that respect relates only to Section Article 25 A and B. Curiously enough, and in the attempt to persuade you, he believes the presumption of innocence and a fair trial from Article 25. He tells you that the Your Honor, that the presumption of innocence.
I need to stop.
So people like us. He tells you that the right of presumption of innocence and Article 50, as protected by Article 25, can be limited under Article 24. That's a fallacy. It's a fallacy, it's a misconception, it's committing injustice and defiling our Constitution. Finally, Your Honor, what is compelling? If you look at the law, Black Law's dictionary, it will give you as to what is deemed to be compelling. That thing must be a strong issue, it must be convincing, it must be legally justifiable. It must be, or it must have the effect of compromising the integrity of the proceedings. None such affirmance has been pleaded. No evidence produced. No law quoted. No case law referred to. And as such, Your Honor, the granting of bail to our client will not prejudice, will not compromise the integrity of the proceedings, will not affect the so-called pending investigations, and Your Honor, be minded of Article 24 and be minded of the test therein. When can a right be limited? A right can only be limited if it is just reasonably justifiable in a democratic and an open society. I invite Mr. Njero to guide us on who next. Thank you.
Now, worried. How long more?
We won't take more than 10 minutes.
10 minutes.
I also give you a case law, Your Honor.
So how long are you?
10 minutes.
10 minutes.
Another
Another
six.
unexpected?
This witness, they'll be very brief. We have 4 more, but they'll be very brief. I'll manage the situation.
Always remember, the court has also business. So you submit here the whole day. You understand the application, right?
We understand.
So we cannot submit the whole day and expect magic. We should be reasonable, and they say, for a wise man, one sentence is
Absolutely.
you don't need to give 100 sentences in circumstances where you can give one sentence. I think that broad guidance serves us right, right?
Yes.
So we don't need to talk, all of us. In fact, I expected Mr. Njero to ground this. There is no need of all of us.
We will be very brief.
We are guided.
So this is Mr. Chesa. Chesa, I'll give you 5 minutes.
Very well. Your Honor, I want to start by raising an issue with the manner of arrest. Which manner violated Article 25A of the Constitution and Section 8 of the Magistrates Court Act gives you authority to inquire into these violations. What this court gave the EACC was search warrants, not search warrants. Which they abused by literally breaking into the accused person's residence in Kitale and Nairobi, bundling him into a police vehicle and detaining him at the Integrity Center offices. We hold that the arrest was barbaric, unlawful, and an affront to the dignity of the accused person. Your Honor, to deny bail, the High Court in Danson Mgunya and another. This is the Mombasa criminal case number 26 of 2008. The High Court said the prosecution must provide cogent, the term there is cogent evidence and not mere allegations. You have been told through the affidavit of Mr. Rono, he keeps referring to some ghost creatures called agents of the respondent. Agents of the respondent attacked ESCC vehicles. Agents of the respondent shouted at Integrity Center, and that's a very serious threat. They have not drawn the matrix to link Governor Natembeya to the so-called agents. Was it Governor Natembeya's wife? Were they governor's children? Were they his staff? There is no such evidence placed before you. And those who amount to rumors, and this court must not listen to them. The accused person, Your Honor, is a decorated career civil servant. He is the governor, government of Transvaal County. He is a deputy party leader of one of the most progressive parties. In all this, he is not a lonely man. At the time, the so-called ghost agents were shouting at the Integrity Center buildings. The governor had been locked up in the police cells. He had no access to his phones. He was only allowed one advocate, Mr. Simiyu. The rest of us were locked out. Jero was asked to get clearance for lead escape. Jero was asked for clearance for lead escape to access his client. At what stage the governor plan with the so-called agents to do the unimaginable things that the state is supporting? Your Honor, in Nairobi miscellaneous criminal application number 351 of 2016, in Nairobi miscellaneous application number 351 of 2016, the court said that the seriousness of the offense per se is not a ground to deny bail. At the time of arrest, 2 more minutes, Your Honor,
I just,
2 more minutes may be done if this court allows. But just have 2 case laws and we can do that 1 case law.
if we can stick to the directions of the courts.
I understand you.
You've already done more than 10 minutes. I gave you 5.
Yes,
I
one
may
more.
close my eye to say you're finishing on the 6th minute.
Okay, yes, 1 more. In that case, you recorded that the seriousness of the offense.
I repeat, one word is enough. I
Lastly,
don't know why we get this temptation, that the more I speak, is the more I persuade. Sometimes it's counterproductive. Can I bring it to your attention?
yes. One,
Sometimes it is counterproductive.
this last one, R versus Richard David Alden. R versus Richard David Alden.
Richard,
David Alden. The High Court at Nairobi. Criminal case number 48 of 2016.
second case. Just list them. I will look at them.
Very well. I think that was the last case, and that the person must demonstrate actual witness interference, not mere allegations.
Straight.
Witness interference. Employees of the county government are retained by county service board, and not the governor. Therefore, there is no relationship between the governor and the employees of the county government, save for CECs who are merely policy makers. That is all.
Your Honor, with your permission, Mr. Simi was the accused person in the ACC. We only say one word. We follow your guidance. If you allow. Mr. Simi. Your Honor, take 2 minutes. And I'm addressing
Proceed, Mr.
Thank you, Your Honor. Your Honor, number one, I just want to write on what Mr. Echesa has said. The accused person did not have capacity to direct. Did not have capacity to direct third parties to commit acts of vandalism. Your Honor, I have an inventory.
Slower. We need your 2 minutes. Let's take it slow.
Your Honor, I'm worried about my 2 minutes. Your Honor, I do have an inventory. Yes, Your Honor, which will demonstrate to you that indeed, as at 6:30 a.m. yesterday, the accused person had lost his 2 phones. And of course, he was in custody. So he could not speak to third parties. So, Your Honor, there are vermins in the affidavits by Mr. Robert Rono is certainly not accurate. Number 2, Your Honor, the place where they went to conduct searches. Your Honor, I want to refer you to the affidavit of Mr. Rono at paragraph 3, where Mr. Rono says that among other places, they went to accused persons Itali Milimani residence. That is repeated at paragraph 4 and paragraph 5 and paragraph 6 of the affidavit. Now, Your Honor, juxtapose that to the order. The order that they received to search the accused's premises had the following residences. One is Rongai residence in Nairobi. 2 is a residence
residence in a place called Kipomet.
Come again?
First is,
No, the second.
second is a place called Kipomet. Kipomet. Third is Nairobi residence in Kileleshwa. Okay. So that, Your Honor, when you turn to the affidavit, and of course they are using paragraph 6 particularly to seek to deny the accused person bail, they are saying that the motor vehicles that are said to have been vandalized were vandalized when they were searching his Italian residence. Your Honor, looking at the order, which Your Honor you can have a look at, the Italian residence is not captured. It's not there. And therefore, Your Honor, we are appealing to you that the evidence that have been annexed to the affidavit is illegally obtained. And we are not very sure that the pictures that are said to be connected to the accused persons are genuine. And Your Honor, to cap that, I would want to refer you to the Evidence Act, Section 106, capital B.
I refer you to SOPEC. Have you read it recently?
I leave you.
Honest to records.
Thank you.
No, I'll try to 3 minutes at max, and you stop your time.
Be sure it is 3 minutes.
Stop there.
Yeah.
The first point, Your Honor, is just to raise point.
Now, I expect you start with what you wanted to raise.
Yes, that's what I'm addressing. Your Honor, Section 106, Appendix B of the Evidence Act is very clear in the manner in which electronic evidence is used. There is no certificate of electronic evidence annexing those pictorials. By dint of that section alone, there is no evidence in support of the bare allegations in the affidavit. There is no basis to even advance now any compelling.
Slow. Let me remind you. The applications contained in the
And in the absence of the electronic certificate, the annexes are inadmissible, and the court should expand them. In their absence, there is no evidence brought to court to support the opposition to bail. Finally, Your Honor, you are told that this court cannot interpret the Constitution. Section 3 of the Judicature Act lists the sources of law in Kenya that this court is called upon to apply. This court can apply the Constitution, including the Bill of Rights. When we say the court to apply Article 49, to apply Article 50, we are asking the court to apply it in the ordinary course of the court's duty. We are not asking for interpretation. Last point. Everything remaining constant, the right to bail is constitutional. And the purpose of giving terms is to compel attendance. The subject of the proceedings is now a warden of the court, not a warden of the state. bail and bond or pre-hearing detention should never be used as a basis to punish an accused person who is still presumed to be innocent. And I urge Your Honor to so consider this accused person as its warden that will attend to court as and when this court requires it. Thank you.
Mr. Jerry, your last soldier. Is it your last or
Listen and then I talk about
Dr. Amino?
Thank you, Honor. I'll take only 2 minutes.
Professor, you said you were taking 2 minutes.
2.5 minutes. Your Honor, we're here before you to demonstrate that what I did recently in my second PhD in criminal justice should be put in the maiden open event. You are the first that I'm hearing before, so I'm very privileged. Secondly, I'd like also to thank my former teacher, Simeo. I think he taught me very well, and that's why I've been proceeding on. Now, the point that I want to make is just one or two. I would like this court to look at the whole history of the government and intergovernment officers calling themselves ESCC and their mandate. I would like to apply what we call strict scrutiny. Strict scrutiny test. Law, whereby the government raises its own legitimate expectation to validate it is incompetency. Incompetency is aligned to rights protected by the Constitution.
Come again?
Incompetency is aligned to rights which are fundamental and protected by the Constitution. If that was the case, then that law must be narrowly, and I mean narrowly tailored to serve a compelling interest. What is a compelling interest? I'll not go into that issue because my senior counsels before me have already spoken about that. How do we look into the classification of what the state has alleged? Classification. Classification, looking at the time of the search, the time of arrest, the time taken to drive, the accused, the miles involved in that journey, the manner in which the accused was transported, where the accused slept, presumably in this case a cold floor, and how the accused was arraigned in court. Lastly, Your Honor, I may not understand, and please let the court make me understand, whether the arresting officer is the investigating officer and is the judge, and is an evidence provider, provision of evidence through affidavit, which even if mandated by statute, and even if that statute contradicts the Constitution, in which case I believe it does, following the circumstances in court, then there's high potency of illiteracy in the judicial, in the government executive system. I rest my case. Thank you.
Professor, are you sure you want that to go to record?
I think it should. because I can substitute.
Literacy in respect to.
Your Honor, what I mean by literacy is not literally academic
Yes.
schooling, but experience. And if we were to do what we call discoveries in law, the kind of affidavit you have seen here raises issues that can only be raised on discovery.
You're admitted yourself.
Thank you.
Daktari, how long? I'm not even sure whether I will fix time for you.
Your Honor, I will be extremely brief, except from asking for one indulgence.
Yes.
I have my own friend, Mr. Ndubi. I always appear with him in the cases. He has only one word that he wants to tell you. That's only one word.
Very well.
One word will take maybe 1 minute or less.
Very well. Continue.
First, you look at the charge sheet. One, the persons named there are two. Particulars refer to one. It is impossible to tell which one we mean, except for the use of the word government. So we don't know whether the Sula is a governor or the Belgian is a governor. The second point related to that is particulars in the charge sheet under the law. And I take the something that the court knows how to do that, right, and understand. Those particulars, which are suggesting that he has committed an offense of corruption, of conflict of interest. The particulars of conflict of interest have not been indicated. So without the indication that what you call the seriousness of compelling evidence is not there. If you look, sorry, we have that code, that was this. If you look at count 2, the same problem of lack of particulars. So that there is not no evidence that demonstrates the nexus between the Natembeya and the brother. And the third count is relates to the manual we going to talk about. Last, and this is about the relation of manual cars and the government. Something I was told when I was being taught to the grandparents when I was not young. We were told monkey see, monkey do. When the government itself gets court orders, citizens have no reason to monkey see, monkey do. When the government routinely violates court orders, it is impossible for citizens to trust it. So nobody will trust that they are doing anything helpful. So the citizens are taking after the government. And very last, I do recall off the top of my head, the governor of Istanbul, who was charged with the blood of support. The court ordered that he should not go to the county government. So this issue of interference with subordinates, if there are any, but my colleague, I just every that's not true. The court has authority and discretion to give conditions that will ensure that the proceedings of this court are currently maintained.
Thanks very much. Your Honor, I was very, very the first point I would like to make to you, respectfully, Your Honor, is that several counsels or advocates have spoken. They have made submissions. I would respectfully urge you that before you write a ruling, a lengthy ruling, very necessary to guide this nation. You release the governor and you tell the audience that I reason ruling will be delivered. Your Honor, this has always been done by the Court of Appeal, by the High Court. This has always been done by the Court of Appeal.
This one?
Giving reasons later
Yes.
has always been done by the Court of Appeal, the High Court, and recently even by the Supreme Court. So I ask you very respectfully that before you rise this morning, you make an order that the governor is released, forcefully, and you deliver the ruling letter. I also ask you very, very respectfully, Your Honor, that you give him a free fall. The governor will go nowhere. We all know it. He lives in this country. He has rendered sterling services to the nation. And there's no way he can leave Kenya for another country. Give him a free fall. And you will also be educating certain people and certain countries that the criminal law of the country must not be abused at all.
Slower, Secretary, slower.
Your Honor, I'm saying to you respectfully that you make an order before you rise.
Sorry, that I scored. Okay.
That the governor is released on a free bond and you will give your reasons much later. Your Honor, permit me to continue.
Continue.
Your Honor, I'm a child born in the colonial days.
You're a child
Born in the colonial days.
of this.
I'm a child who received education in colonial institutions. I'm a child who read colonial literature of sociology, anthropology, philosophy, when we had terms like the African mind, how the African things and so on from the colonial days. There's one thing I can make you very clear. The criminal law of Kenya has always been abused. It has always been abused by those in power. It was abused during the colonial days. It was abused during Musalia Mudimeta's days. It was abused considerably during Moi's days. The only president that can put in a word in his favor is Moi. The criminal law was not abused during the
I think the statement is home, Secretary. The statement is home.
Oh, thank you very much, Your Honor. Now, Your Honor, permit me to go a little bit further. It is now being abused by the executive, by agents of the state. They have now taken over the criminal law of the country. They are abusing it. The rule of law which we thought was improving is now in ICU. And Your Honor, I'm urging you very respectfully that you can only get out of this quagmire with boldness from the judiciary. Our judges have to be bold. Our magistrates have to be bold and state very clearly that the country will not be governed the way it is being governed at the moment. Your Honor, we live in this country. Every day I'm reading the Senate, I'm reading the Nation, I'm reading the Star, and I go even further to read any other newspapers outside this country. Clearly, Your Honor, what is emerging at the moment, that unless we arrest the situation, nobody will have confidence in the country. The country could easily be classified as a banana republic. I filed a case recently, Your Honor, in court, the usual process, that we should refer certain matters now to the ICC.
Your Honor,
That we should refer certain matters. Your Honor, the judge you are given here, one can even pass into absence. The first comes. The governor is supposed to have corruptly received the sum of shillings 1,127,900,000 shillings. You're not being told that he took away billions of shillings. 1,127,900,000 shillings. Anybody with a critical mind like of John Hamilton can see that this is dishonest. It's nonsense. That you're bringing a governor of the state to the country because of that amount of money. That's on the first page. On the second page, 2,124,668. Hey, what is that? It's a full governor. 2,124,668. That's the honor. The amount involved is 2,680,461. This is of Emmanuel of Musugo. Your Honor, the criminal law is being abused. During the days of so let me make one point clear. A constitution has been meaningful, it must develop something called convention. A constitution is meaningful, it must develop in some cases something called convention. You would expect that a charge against a governor of the country, the director of public prosecution, would lead the entire file to satisfy himself that indeed a case has been made out before placing such a case before a criminal court. Your Honor, when did the DPP read the file to satisfy himself that a case has been made out against Mr. There? Having regard to what was being told, was arrested with yesterday morning. When did the DPP read the entire file? And this, if I may say, in favor of Charles and Johnson, he would read the entire file to satisfy himself that indeed a case has been made out against the government. A governor is no small man. A governor is not a messenger. A governor is a person who is ruling and governing millions of people. It is therefore not surprising that the people in his own area were mad to hear that their governor is being arrested. He's being brought into the country, taken by the police. It's quite clear the file was not read at all. Your Honor, may I say, draw your attention to the fact that I shall, if I'm given the opportunity, I shall be conversing in some other quarters that the courts have no jurisdiction to contain the count that they have to that people. There's no jurisdiction at all. And I would refer you to Article 181 and Article 182 in the Constitution. If you read Articles 181 and 182, Your Honor, there is no provision that provides that a charge can be prepared against a governor. The way to deal with a governor is to use the impeachment proceedings that have been provided for in the Constitution. A governor cannot be arrested and charged the way things have been done. The director of the execution himself, Your Honor, the DPP has no jurisdiction to make or to prefer charges against the government. So there is lack of jurisdiction. I'm making this point to strengthen my submission, Your Honor, that there is no case against the government. In this thing. Your Honor, one final question, or one final submission on the next year. Please don't misunderstand me at all. I've often thought that in a country like Kenya, strictly speaking, you do not have these rights. You do not have these rights in the law at all. What is required of a lawyer? What is required of a magistrate or a judicial officer is to be strong and to be courageous. The mind in your face that rise to the occasion and show those who are in power, who are in executive, that your powers can be challenged, that your powers can be reduced by the court. And it is the courts that are in control of the country and nobody else at all. If we lose the control of the court of the country, if we lose the power that the courts have, Kenya can easily and very shortly be classified as a banana republic. No wonder that the president of Tanzania said the word that he said about our country. The country has gone up. And we need young people like yourself, the honor who have got power, to see whether we can bring out and maintain the concept of rule of law in the country, independent of the judiciary, and make sure that we can use the word and they borrow the word of our president, that let the executive keep its own day, not to get into other days. And currently, it is not doing so. Thank you, Your Honor. I think Your Honor. Yeah. Your program may say that when the matter I handled in some other quarters and so on.
Mahatma.
Yes, there is a book here I will be referring to impeachment in the Nigerian presidential system. That's where we have a lot of impeachment for governors and so on. And I will be borrowing words from this book. I'm just putting my learned friends from the prosecution notice that they order for this book.
What is the title?
Order.
Types of the two. Your Honor, I'm taking the title. It's impeachment in the Nigerian constitution. I assure the very learned senior that you have come.
Yeah. I don't know if it's on the impeachment of a governor, Your Honor. And in Nigeria, you will see when members of the executive swearing that they would rather die than have such a governor in power. Yes, some people, I'm sure, are swearing that they would rather die than see Governor Natembeya in power.
Very well. Mr. Njero, I think we are done.
Yes, we are done with
Yes.
Our father. The father, the profession, he has said it all. Give the governor favor. At the very worst, some affordable cash flow. Let him not stay here an hour longer, so that we don't play in the hands of his tormentors. Let there be no conditions. This man has been elected by his people. He has committed no wrong until the case is proven, if at all. There was not even any affection in that effect. So let's not talk about conditions. In fact, that date, one of these expanded. Let him get his free vote or cash bill, let him leave. Even a street boy here will know who's talking up in there. There's nowhere where he will go. We believe, Your Honor, you do the right thing. We have no doubt at all I for one have no doubt. I know you are a good police officer, you believe in the rule of law, you understand the law, and even as we are doing all these things, you've appreciated it. I have no doubt that today the judgment will have no doubt. No conditions have been sought and shouldn't be desired. Let man go and serve. He'll have his day in court. Thank you very much.
Sorry, Your Honor, do we have a right to respond?
Of course, there are any cases. Mr. Owiti,
Yes.
together with who?
I'll just go alone. Most
You have
kindly.
not specified.
Yes. Your Honor, start with the jurisdictional issue that has been raised by counsel, especially the very learned Dr. Amino, as to whether or not this court properly has jurisdiction to entertain these charges. Yeah, proceed. Yes. And whether or not the Director of Public Prosecutions had power to institute these charges.
Yes.
And that is related to reference to Articles 181 and 182 of the Constitution relating to vacancy in the office of a county governor in Kenya. I believe, I haven't made reference, but I believe that's the position. In brief responses, this court's jurisdiction to entertain anti-corruption matters is provided for under Section 4 of the Anti-Corruption and Economic Crimes Act. So that's a simple answer. Section 4 of the ASEC. ASEC is a law. Point of law is ASEC. So this court has jurisdiction. The Director of Public Prosecutions is vested with power to institute criminal proceedings against anyone before any court other than a court martial, Article 157, 6A of the Constitution. Allow me to make two corrections. My very good friend, Mr. Degwa, tells the court that there is no nexus between the affidavit and the charges. And if your record confirms what I also heard, that there's no such charge as conflict of interest, which is count number 1. I don't know whether counsel read the charge sheet. Count number 1 is conflict of interest. And not just that, count number 2. How could he have gotten that wrong? Conflict of interest. And it does not only mislead you on that. He says that the prosecution, on behalf of the prosecution, no law has been pleaded, no evidence has been produced, no case law has been referred to. I refer to Tom Chomley, it's case law in Kenya. I quoted Article 49(1)H. I quoted Section 123(a). These are laws in Kenya. The second correction, Your Honor, my learned senior, Mr. Masharia, if I don't get that wrong, tells the court that the areas, the subject of the warrants issued on 18th of June were limited to 3, Kibomet and another one, it's on the record, Your Honor.
Sharia or Sibiu.
Oh, Mr. Sibiu, I apologize, that's why I was not sure who's in. Your Honor, although they have not given you a copy of that warrant, it says, and any other part just read that so that I get it correct, so that I don't mislead the court. The warrants have been referred to, just below the areas listed, there is any other office, business, and residential premises wherever they may be situated within the Republic, unless we are reading different ones. So that even the search in Trans Nzoia was by law, was sanctioned by law. And then there's the related question as to whether the warrants issued could also be the basis of an arrest. That is the question asked by my learned friend and teacher, Mr. Chesa. Your Honor, this is a cognizable offense